gentlemen, what is the difference between a civil case and a criminal case? Alex, I'll start with you.
Yeah. Well, just to, I guess, easily answer that, it's a very drastic difference in the burden of proof between the two different settings. Criminal cases have what is the hardest standard or threshold the prosecution would have to meet, and that's beyond a reasonable doubt. Everyone tries to explain it, but there's really no other way to explain it. It's just beyond a reasonable doubt. And that's basically the state would have to prove that there is no sort of second theory or doubt that the named defendant committed the crime. Now, I know kind of getting into this, just to kind of piggyback off of that, that's not necessarily the doubt threshold that Deshaun Watson faced, in his criminal side, because he never made it past grand jury. So some people kind of, some stuff I see talking about it mentions that while that is partially correct, it's wrong because he wasn't in that realm of a criminal trial. At grand jury, it's a probable cause type of threshold. So they just have to show, there's a reasonable likelihood that these offenses occurred or that this person could be found guilty of an offense. It's a little lower threshold than beyond a reasonable doubt, but I mean, it still has to be credible evidence to show that, the grand jury could find that, there's a reasonable, inference that this offense could have occurred. So that is like the biggest difference between criminal and civil. Obviously has the hardest burden of proof. But I just kind of want to add the caveat, given what we are seeing in the sports world today, that's not necessarily the standard across all criminal sort of proceedings. Then on the civil side, it's what's called by preponderance of the evidence, which is just more likely true than not. Some people call it, 51%. You just turn that book one page over, or 50.0001%. But you can obviously tell by how I'm explaining it. It is an easier burden to meet, but still can be a hard one depending on the facts of the case. But that is what you see in any sort of criminal setting, or not criminal, sorry, any civil setting where, a plaintiff is trying to get monetary damages or some sort of injunctive relief or a declaratory judgment, something that doesn't come in with a prison sentence and is mostly about liability and money. But that is the two biggest, that is the difference between the two settings is the burden of proof and the difficulty that the party bringing the suit or bringing the charges would have to prove to win their case.
And John, from your perspective, looking at those two, I mean, those are the definitions as I understand it, I've read. Generally speaking, in terms of U.S. law, would you have anything else to add to either of those?
A lot of people look at the criminal standard as, beyond all doubt or beyond a shadow of a doubt. And those aren't the proper terms to use. It's beyond a reasonable doubt. Would a reasonable person looking at these facts have some doubt about the guilt of a defendant? Alex mentioned the 51% standard for a civil case. The next step up from there is clear and convincing evidence, and that is the standard that's used in, say, a child neglect standard, where you're determining whether or not someone is an unfit parent to the degree that you would actually take their children away. Beyond a reasonable doubt is above that. So in order to convict someone of a crime, you have to be more convinced of their guilt than you would be if you were assessing whether someone should have their children removed from the parents. That's how high the standard is. If you were going to assign a number to it, again, the 51% standard for a civil case, beyond a reasonable doubt is easily north of 90 to 95% of the evidence needs to be against a criminal defendant. And that is a difficult burden. You need to be pretty darn sure that you are correct of someone's guilt before you're going to deny them of their liberty, before you're going to put them in prison.
No, exactly. That's, again, between both of you, that's exactly how I understood everything within the system there, which is when you see some of the comments and whatnot with regards to, specifically with regards to the Watson case, I think that's where some people were struggling to understand why the civil cases were able to proceed and the criminal cases were not. And that's simply due to the burden of proof. Now, John, just on your feedback, I'll start with you on this one, directly related to the criminal side. One of the things that was pretty rare, as my understanding, particularly in U.S. courts, which was in a case that had this much publicity, having the judge rule from the bench, specifically on the Watson piece, on saying no. What was your feedback or thought process on that?
I assume you're talking about the grand jury.
Yes, the grand jury. Yes, the grand jury. Yes.
That's not a judge. That's a body of people like a jury.
Yes.
But their only decision is whether or not to indict or not. There is a saying in criminal law that a prosecutor can get a ham sandwich indicted by the grand jury. That's how easy it is. So that certainly calls into question just how hard the prosecutor sought charges, how they framed the case to the grand jury, whether or not they really exercised all of their efforts to obtain an indictment, or if they kind of phoned it in. So ultimately, the members of the grand jury decided that there was not enough evidence to indict. Now, my understanding of the facts, and I certainly am not privy to any behind-the-scenes stuff, is that Mr. Watson is alleged to have contacted, certainly into the tens of women. I've heard, certainly 30. I've heard other broadcasts talk about north of 60 women.
Yes,
it's a lot.
A lot of women. And he was soliciting their massage services, and then he is alleged to have gone further than that and either physically or otherwise coerced them into performing sexual acts. Absolutely, that is a criminal offense under any state's definition of sexual assault or variations of sexual assault. When he is alleged to have brought women across state lines, then you start getting into federal criminal jurisdiction and the Mann Act and transporting women across state lines for the purposes of prostitution. Now, because there is some implication that these women have colored pasts, and whether or not they had been doing this outside of Mr. Watson's situation, I think that probably cast some questions to their credibility moving forward, and I think ultimately that's why the grand jury had a hard time.
So basically, what you're saying is when the grand jury assesses the situation, they have to look at the credibility of those who are accusing. They have to look at credibility of evidence. They have to look at all of those sorts of things being factored in prior to indictment or not. Now, Alex, over to you just on the same topic, because again, this is one of the big pivotal moments, if you will, in terms of the Watson scenario here. With regards to the grand jury not indicting, especially in something that had this much publicity, from my recollection, is rare. Just maybe it's a biased opinion on this, but it certainly seems rare. What are your thoughts on that? And that kind of angle and of that kind of decision, if you will, to add on to what John just said.
Yeah, I mean, I will preface. I don't necessarily have a grand jury experience to give you a firsthand battle story or whatever. But I thought when this all happened that the fact that you had two different counties, two different police departments, two different investigations, both move forward to a grand jury setting. I thought, at least one of them, if not both, like there's no way that they don't come out of that with nothing. We're not privy to what evidence was out there, what was used, what testimony was presented, or anything else. So, we don't really know how those settings actually went. But I just kind of thought it'd be curious to see how many people, cooperated fully with the investigations and everything, given the civil stuff going on. And then I also thought that probably it was a credibility thing with some of the witnesses and people involved, because you had evidence of sort of blackmail. I'm not going to say anything if you pay me 200 grand now, or I'm going to go to an attorney and stuff like that. That probably diminished, how sort of a grand jury would look at them. But it's hard to know exactly what goes on in the juror's mind, but and what piece of evidence, no matter how big or small or whatever they witnessed, was like the pressing point for them to not move forward. And that's kind of the beauty of the court system anyways, right? There's so much analytics you try to do, and it could be, just how some random person looks at it.
Yeah, and I think that's part of the reason why you end up in some cases where certain jurisdictions will lean in certain directions. Some of that is just how those particular historical interpretations of the local laws as well as the federal laws, and that's why you end up with such varied decisions actually across the country. Is some jurisdictions will add nuance into what they read in the laws and constitution and whatnot, whereas others will not, and they'll rule maybe more literal or what have you.
Rich, there's also another prism to look at this through. District attorneys are elected officials, so yep. There is a political aspect to this. Mm-hmm.
Fair enough.
And I'm not as familiar with Texas criminal law as I am with Colorado. Colorado certainly has grand juries, but it's not a requirement to go through a grand jury in order to file a felony case. It's possible that the district attorney wanted to take the politics out of it and give the case to the grand jury and let them decide whether or not they were going to file a case, as opposed to the district attorney just filing it on their own. I'm not certain what Deshaun's popularity level was in Houston before this, but I'm from Houston, and I know how popular the Oilers were when I was a fan there. I left before the Texans became a thing, but there is that possibility that to the degree that the district attorney did not want to appear to be making a political decision in a Me Too environment, that they assigned the case to the district attorney for the very purpose of trying to remove politics from it. And that decision in itself is a political one.